Yes.
Oh, okay. Maybe sit while you breathe. Everywhere but you. Yeah, you are too.
Oh, Marcus.
Every time I've been in this office, like it, but it's
Whole different experience.
not nearly as good. So I guess it holds.
Come sit by you, is that what happens?
I think I was in your apartment.
Very narrow.
All right, awesome. So we'll get started. Hello. All right, sweet. First off, welcome. Aggies for Liberties, excited to have you all here. First off, I want to thank Strata for allowing Aggies for Liberty to have our event in this venue. And so quickly, I'm going to introduce myself. My name is Zach. I am the current president of Aggies for Liberty. And then a brief introduction of the plaintiffs. We have Laurie Wood here, Cody Partridge, sorry, Derek Kitchen, and then Moody. Yeah, I'm sorry. And then we have Ryan Yonk, who's going to be the mediator. So I think that's the moderator. Oh my gosh, I always get the name wrong. So just a quick run through of the event. So I'm going to hand off the mic to Grant, who's a member of Aggies for Liberty. And he's going to do a quick run through of the case, and then he'll hand the mic off to Ryan, who will do a brief introduction of the individual rights. Oh, hey buddy. The individual rights behind it, and then from there Ryan will take it away. So with that, we'll get started.
All right. Thanks. So I'm just going to talk briefly about Utah's Amendment 3, the history of it, and the history of the case. So Utah's Amendment 3 was passed in November of 2004. The amendment itself stated that marriage consists only of the legal union between a man and a woman, and no other domestic union, however denominated, may be recognized as a marriage or given the same or substantially equivalent legal effect. In March 2013, 3 couples sued to have Amendment 3 overturned as unconstitutional under due process and equal protection clauses. Their names are Derek Kitchen, Moody Sabetti, Karen Archer, Kate Call, Lori Wood, and Cody Partridge. In December 20th of 2013, Judge Robert Shelby of the U.S. District Court for Utah, he granted summary judgment to the plaintiffs, which basically means that he thought their case was so good that they didn't even need to go to trial. He could just rule right then. In the
That was on December 4th.
Oh, it was on December 4th.
Well, he ruled on December 4th. It was on December 20th, but December 5th. The motion was.
Okay, cool. Thank you. Yeah. So in the decision, Shelby wrote, Utah's prohibition on same-sex marriage conflicts with the United States Constitution, guarantees of equal protection and due process under the law. The state's current laws deny its gay and lesbian citizens their fundamental right to marry, and in so doing, demean the dignity of these same-sex couples for no rational reason. Accordingly, the court finds these laws unconstitutional. From December 20th to January 6th, over 1,000 same-sex marriages occurred before the Supreme Court issued a stay on the district court order. Utah appealed to the 10th Circuit Court, but on June 25th, 2014, the 10th Circuit affirmed Judge Shelby's decision and immediately issued a stay, waiting for Utah to appeal to the U.S. Supreme Court. It's unknown if the Supreme Court will take the case. If they do not, then the 10th Circuit decision will be final, and same-sex marriage will be legal not only in Utah but in all states that are under the 10th Circuit jurisdiction, which includes Colorado, Kansas, New Mexico, Oklahoma, Wyoming, and Utah. If the Supreme Court does take the case, as is expected, then we'll have to see what happens. But this could, change the entire country. So, yeah. Thanks.
Thank you so much. So let me just walk you through a little bit of how we're going to proceed over the next about 50 minutes. So this is a moderated panel, so we've invited the plaintiffs in this case to come and share some of their thoughts. So we'll start with about 30 minutes of question and answer from me to the panel, and then for the last 20 minutes we'll open it up to questions from the audience. And so as we proceed through that, there's just a couple of ground rules in any panel discussion that are worth noting, and that is one of the things here at Strata in particular that we value is the open discourse of a variety of ideas. And so you'll notice tonight we're hosting this panel, and next Tuesday we have Senator Mike Lee in. Two events that are, yes, it's a nice bit of symmetry, I must say. But the open ideas, the transmission of free ideas is an important part of how a society flourishes and prospers. And so as you ask questions tonight and as we think through these things, that's the spirit in which we're hoping this event proceeds along. So as we start, one of the most interesting questions I think that's bubbled up across the course of the discussion, both of Amendment 3 originally, which some of us remember that battle. There are a few folks in the room that were probably too young to really remember that fight. It was interesting talking to a lot of the students that work with us here at Strata. Some of them don't remember the fight all that well. And it was a fight, despite the fact that it passed with about with over 60% of the vote. The discussion was lengthy, animated, and ultimately one that we knew was going to have to be resolved through the courts at some point in the future. And so as we begin to think about what that means for folks, we're interested in particularly the individual rights piece of this. Aggies for Liberty, which is an affiliate of Students for Liberty, as well as Strata, are both premised on the idea that individual rights, free people, acting in a free society lead to better off. And so as we think tonight, as I ask the questions, my questions will all have an individual rights focus. I can't promise what the audience will ask. So on that note, we're going to go ahead and proceed if that's all right. So the place I think we ought to begin, so here's the mic. I will just sit there a moment. So the reason why we have the mics tonight is it's actually being live streamed. We certainly could hear everybody in here, but the folks that are trying to watch that couldn't be in the room, it's on YouTube through the Strata YouTube channel. So that way they can log in. So if you'll use the mics, that will let them hear. If not, Ian, who's running the camera in the back, will wave his arms really big to try to get my attention. I'll probably ignore him, so if he's waving his arms, say, maybe you want to look in the back, Ryan. So if you'll do that, that would be great. So the first question, where I really want to start is, it's pretty clear that the results from Judge Shelby and the 10th Circuit started an avalanche across the country. District courts and appellate courts have now taken up a number of cases. And in many ways, you all were the first. So what's it like to be the plaintiffs in that start of an avalanche case? Whoever wants to start can go.
Well, first off, we were the first case to be heard in a district court, but we really owe thanks to Edie Windsor and the striking down of DOMA. That was a big case that really helped us a lot. We had no intention to start an avalanche, and we had no intention to create what has happened. Our only want, really, and our only need was to be able to get married in our home state. We have homes here, we have businesses here, our lives are here, our families are here too, and so it has been a very exciting process. we don't know what to do with the spotlight. But we really hope that we win at the Supreme Court if they do take our case, just so we can continue to live our lives.
All right, Cody.
I think because we filed our case before DOMA was decided, that's something that sometimes gets lost. Not that it's been that much easier for the other cases, but it has been. I thought Judge Shelby was brave, even though he followed the Constitution and interpreted the law. It still took a lot of bravery. And I think every decision that has come since then has quoted Judge Shelby. And so I'm so grateful that he took the time and wrote such a thoughtful decision. And that we, I guess if we're going to start an avalanche, I guess to be on the front end of the avalanche is probably a good place to be. I sort of think of it as the train has left the station, and not necessarily that we're the engine, but it is nice to know that our Judge Shelby, was so well spoken and well written that others have turned to him for their decisions.
So one of the things I think that comes up from something you said, Moody, was there's a lot of questions about what makes someone decide to hop into the middle of what I'm going to guess you sort of knew was going to be a high-profile case. I can't imagine a scenario where your attorneys weren't pretty clear that that's where this would go. And so what was the motivation to be willing to put yourselves and your relationships under the level of scrutiny that's pretty clearly come from being participants in this lawsuit?
We were just asked this question a moment ago, and one of the things that have facilitated our ability to join this lawsuit is I teach at a private school, Roland Hall St. Mark's, and when we were considering whether we should join the lawsuit, I emailed my principal and said, I'm considering doing this. What are your feelings? And he said, this is your decision, and we support you. And so that has been lovely, because I'm not sure, and Laurie feels the same way. She teaches English at UVU. She's tenured. And both of us felt like we had the luxury of being able to step up where others might have wanted to, but did not feel like they could. So that, and we believe in the case. We believe in marriage equality. We believe in individual rights and protecting those individual rights.
And for us, I think our biggest concern was our business. When we first filed our case, we had only been around for about a year, just shortly over a year. Laziz, which you can taste in the back there. We do packaged Middle Eastern
excellent.
But for us, our biggest concern was the public perception. A big chunk of our business comes from the farmers market and interacting with folks who come from all walks of life. And I think that as we were entering this case and mentally preparing for what might be a high-profile case, not nationally but locally, we were worried about how our business may suffer. But luckily, we have very supportive families. At least I do here locally. Moody's family is from Lebanon, and we didn't really run it by them before we decided to file. But yeah, it doesn't count. But luckily we do have supportive families. And one thing I should note is, last Christmas, 5 days after Judge Shelby gave us his ruling, my family, who just happens to be relatively conservative, given my upbringing, they came to me and they said, Derek, we're thrilled to have our last name tied to this case. We're honored to be involved, and we are here to support you no matter what. And I think having that backbone really allowed us to move forward with ease.
Just to add to that, Derek's family is not just conservative, but they're also very LDS. And that really goes to show that the Utah community is very supportive, no matter what their political affiliation is or what their faith is. This really is not an issue that boils down to personal belief. This is really about human rights.
So I want to talk a little bit about the way the decision came down from Judge Shelby, because for me it was a surprise. I'd been following the case proceed over time. It felt like a pretty routine set of summary judgment motions from both the plaintiffs and the state. Both felt really routine, and then it wasn't. Sorry, go ahead.
Our attorney argued for about an hour and a half, which is not routine.
Her argument's not routine, but let's be honest. Almost every case proceeds with a request for summary judgment, and it's highly unusual for summary judgment in a case potentially as complex as this one to be granted. And so I'm curious how you felt once the summary judgment decision came down, with the lack of a trial. Were you certainly the state was disappointed in the lack of a trial, and I'm wondering how you as the plaintiffs felt.
Well, when we heard of the news on December 20th, we were in our kitchen roasting eggplants, so we were not expecting it on that day at all, because Judge Shelby said that we would have a ruling by January 7th.
Right.
But really, the minute that happened, our phones just blew up with texts and calls and Facebook posts, and then we found out that so many of our friends were rushing down to the county clerk's office to get married, and it was happening. We at first it seemed so unreal, but it was happening, and there was this sense of just excitement and jubilation, and we've felt so cornered in the past and so kind of put in this box, and it felt like the walls were just crumbling down, and it felt so powerful, and so unexpected, completely unexpected.
Unexpected is probably the best word, because although we were hoping for a ruling in our favor on summary judgment, we definitely were not expecting marriages to start happening. We thought for sure a stay would be issued. And I'm not sure if it was just the Swallow Shirtlift scandal that had the Attorney General's office in chaos and unprepared. But lucky for us in our community, families were able to get married, and I think that that day was really, really special for many people in our community, and I'll never forget how exciting it was for all of us.
Laurie had visited her mother on that day and just returned home. I had been working with students unloading food for food giveaway, and again the phone started ringing, the emails started coming in. Her brother said, "When are you guys going to get married?" And it was amazing. It did catch us all off guard, because Judge Shelby on the 4th had said you can expect a decision by the 7th of January, and then he ruled early and in our favor. And I think Laurie and I did decide. I'm 48, she's 59. We decided we're going to seize the moment, and we're married on the 20th. And I will tell you, it was amazing to be able to exchange wedding vows with this woman, with the woman I love, and to see others doing the same. And it was 17 celebratory, jubilant days where families' commitments were recognized, and we're just grateful for that. And again, Judge Shelby's ruling was so well written that we felt very secure in our decision to exchange vows.
Great. So let's turn a little bit to talk a little bit about Judge Shelby's ruling, because it's pretty heavily anchored in the notion of individual rights, tied it directly into portions of the Constitution, actually not just the 14th Amendment, but a number of others. And so one of the fundamental, I think, disagreements between the state and the plaintiffs is whether or not the right to marry is in fact covered by the 14th Amendment. And I'm wondering if you'd share your thoughts on that, if you have any.
Excellent. I assumed.
It's interesting because the state has constantly been trying to make the case that it is a state's right and that it does have a compelling reason to be able to define marriage and decide who gets married. And it's frustrating sometimes to hear their arguments because they want to make marriage all about being able to reproduce. And to be able to reproduce, they call it responsible. Gays and lesbians are rarely irresponsibly reproducing. It's one area of a very, very responsible. And I think the state, in trying to regulate what marriage means to everyone, gets into really dangerous violation of privacy, I think, because it would set up some requirements for everyone who applies for a marriage license to prove that they're able to have children, they're fertile, that they're willing to have children, that they in fact are going to try to have children, all those sorts of things that really the state has no business in being involved in. I know people who interpret the Constitution are worried that fundamental rights, that you can't just keep pulling them out of a hat and keep calling things. But I don't think you can have the argument that marriage is so important that it's the very fabric of our strength as a nation, but you can't have it. It's not important to you. It's not fundamental to your well-being. It's not fundamental to your happiness or pursuit of happiness. And so I think if anything is going to be declared a fundamental right, I do think something that adds stability to the citizenry, to make our societies more civil. I think marriage is one of those rights.
I just think, in any court case, it's never good to be the one arguing for limiting rights, and that's where the state's at right now. And so that's I think they're going to be disappointed. They were disappointed at the district court. They were disappointed at the circuit court. If the kitchen case is the one to go to the Supreme Court, I think they're going to be disappointed there again. And let's keep in mind that time and again, historically, the United States Supreme Court has held that marriage is a fundamental right. Not, opposite-sex marriage, not white marriage, not black marriage, just marriage. And so I do believe that, as we proceed and as we put forward our arguments to the justices at the Supreme Court, assuming we get that far, I think that we have a real good shot at legalizing marriage for all citizens.
So one of the sort of libertarian critiques of the case, and this is a fascinating critique, it's been advanced by self-described libertarians like Connor Boyack in the state, is that fundamentally the solution to this entire problem is simply to have government leave the realm of marriage altogether. And that's a critique that, at least for me, sounds really nice, but there are some problems with it. And so I'm wondering if you'd respond, is Connor's suggestion and others a solution to this problem?
I think that's a fantastic solution given a different context. In Europe, for instance, you go to the state for your relationship certificate, and then you go to your congregation, your church, whatever that may be, and you get your marriage within the privacy of your own belief system. Unfortunately, in the United States, we have institutionalized marriage, and it has become something that the state grants to people, and there's a certain amount of rights and responsibilities and freedoms that come with marriage, and so I do agree with that in theory, but it's completely unpractical in this sense.
Well, most economic theories are a bit unpractical, aren't they?
Yes, we got a list we can go through, Moody.
The argument that comes up all the time is this freedom of religion, and that's such a good argument because I wholeheartedly agree. There are so many religious institutions out there that wish to marry same-sex couples, but they can't. Right?
I want to reference when the 10th Circuit issued their decision, and this is kind of taking liberties with your question, but what I saw as really important is that Judge Lucero carved out a space and said, we can respect people's belief system, and we can see the importance of respecting people's constitutional rights. And I would like to believe that we can have a win-win situation where families and couples, straight, gay, can be married, can have that legal recognition, can have their love recognized, and people can have their belief systems, their faith, and that can be respected as well. And as Derek said, getting back to your question, I mean, right now, it seems an interesting theory to consider, but as our system works, perhaps impractical.
We've had a lot of our straight friends who have been married for a long time suddenly stop and really think about what their marriage means and how many rights and privileges. And I think there's something like 1,100 benefits that come. And I cannot imagine the people of Utah or of any place lining up to say, okay, I'm giving up my right to inherit Social Security, my inheritance, my right to make medical decisions, all those things. Those people making those decisions or those suggestions have not really thought through what comes when you have that certificate.
So part of the place I think we will turn as we wrap up this portion of the discussion is the slippery slope argument that comes out inevitably, I think, in these discussions, and that is that by moving down this path and granting that marriage is a fundamental right in this case, will that end up leading to the sort of parade of awfuls, is what I'll call them, of polygamy, and if you listen to a few others, things far beyond that. So I'm wondering how you'd respond to the slippery slope argument that gets brought up by some who oppose marriage equality.
In teaching English, 11th grade, I teach an AP really rhetoric class, and I teach my students about logical fallacies, and one of those is the slippery slope argument. And I feel like often when people use that line of logic, it is intended to scare people. And I don't think that makes for a great dialogue about what we're really talking about here, which would be two consenting adults who want to make a legal commitment, a commitment that we see as sacred, that we take on very seriously, and are humbled to do so. So I think that it is a huge leap in logic meant to confuse the issue and to create fear.
Well, two or more.
Well, 2 days before we were in the district court on, I think, December 2nd, maybe 1st or 2nd, Judge Shelby's colleague in the district court struck down portions of Utah's ban on polygamy. And I think that that's a conversation worth having. It has nothing to do with what we're arguing. Although, we can have a discussion on the constitutionality of whether or not it's appropriate for states to ban polygamy. And I think that, maybe we will be having that conversation in the near future, but I guess we'll have to wait and see there.
Just to humor you guys, before we went to the 10th Circuit Court, there was an attorney that filed with the 10th Circuit Court requesting to marry his computer. And of course, that was denied. But that slippery slope is dangerous, as Cody said, and some people will try and make it seem real by filing to marry their computers. A lady once told us if we plan on marrying our dog. So I think it's really fear-based.
So as a short follow-up, so what are the boundaries then, as we think about where are the bounds that you would put on public policy for this?
I think it's two consenting adults of legal age, whatever that age, we as a society agree on, that choose to honor a relationship amongst themselves.
And I do believe that we, as a society, are moving past the gender discrimination, and basically the ban against same-sex marriage is basically one about gender. And so I think this is just part of the evolution. It's probably someone's idea of the slippery slope of what the feminists wanted in the 70s. But we're moving beyond that, and I think that as we evolve as a nation, our ideas of things, our worlds get bigger, and I think we've moved beyond that. Only men can have property, and so we've moved to the point where marriage is between equal partners, and we shouldn't discriminate against one sex or the other in that partnership.
Great. So at this time, we'd like to go ahead and open it up to questions from the audience, if that works for the panelists. So I'll go ahead and move the roving mic around as people have questions. So if you'll raise your hand, that would be great. And I'm going to get out of the chair finally. So Jason really wants to be first.
I could probably shout loud enough.
But we need you to be able to be heard by the rest of the online group.
In the early coverage of the initial ruling from Judge Shelby, it was discussed a lot. It's kind of faded a little bit from discussion about this, but there was discussion of the word animus was used a lot in discussion of, and Ryan, you'll remember this from the passage of the amendment itself. Huge discussion over this at that time too. There are two separate parts of Amendment 3. Can you talk a little bit about that second part and animus when it goes that extra step, and how that's played into the legal challenge so far and might going forward?
I remember when Amendment 3 was being debated, not just within leading up to the election, but on the floor. And I remember listening to LeVar Christensen and LeVar Christensen and Gail Ruzicka, the architects of Amendment 3. And I believe truly that it is based on animus and fear. And I believe at the time it worked really well. Keep in mind this was 2004. This was the re-election year for George Bush. He was running and winning on gods, guns, and gays. And that was really his platform to scare people, in my opinion. And so there was a lot of animus. We have gained as a community, gay, lesbian, transgender community, we have gained a lot of ground in the last 10 years. And so I think that many folks who may have had a sense of animus as Amendment 3 was being passed, and similar marriage bans around the country, but I believe that many people who may have historically had animosity or feelings of fear have since changed their minds, and of course LeVar Christensen and Gail Ruzicka have not, but I don't believe the animus argument is, I mean, we can talk about Amendment 3 being drawn up around animus, but we don't need animus in order to win. We don't need to win with winning on that, I guess.
I mean, I love how Derek answered that because it is about his personal experience. In my personal experience, some of the comments made as we were debating Amendment 3 did feel disrespectful, that were based on fear. In terms of the legal argument, I agree again with Derek that we don't need it to win. And I've seen some articles that how some of the justices of the Supreme Court might define animus would be very different than we've been talking about. So again, in terms, Judge Shelby didn't feel a need to, that he had to prove there was animus, that he could still rule in our favor. And so I know it's an important issue and people talk about it, but I don't think it's the linchpin.
Other questions?
I'm just wondering if you could address those arguments of those people who would say that why marriage? Can't you just have a civil union? You know, what's the difference? Why are you fundamentally going after marriage versus a civil union to discuss that? Thank you.
In terms of our own home state, Amendment 3 did not allow for civil unions. And that is why I think Ryan talked about this. Early on, there were people who probably did not support gay marriage who said Amendment 3 goes too far. Now we would say all of it goes too far, I think. But I do think that is an issue. It wasn't even a possibility because of Amendment 3 in Utah. In other states, it's not. You can't be civilly, engage in a civil union in one state and it doesn't carry over to another state necessarily. Marriage does, and that is important.
In terms of a civil union, you're asking us to accept discrimination. You're asking us to accept a two-tiered system. It's the same thing as you're black and you can drink, but you have a separate drinking fountain. And on top of that, civil unions do not give us the full range of rights that a marriage certificate has. This whole separate but equal argument is not. You cannot be separate and equal at the same time. And who the hell says I'm going to get civil unioned? That just doesn't sound fun,
We make a lot of things verbs in the States.
Okay, so from a real libertarian viewpoint, would you be in favor or would you not be in favor of simply no benefits to marriage, no state involvement? If you want to set up something, for example, with your computer or with your dog or with your brother or with some other person, you can set up a legal arrangement that they get certain benefits, but of course things like Social Security they wouldn't get. But for society, if you're talking about this and you're saying somebody else gets better benefits, would you be in favor of, okay, no benefits to marriage? If you're a single person or if you're not married to someone and you live with them, you can make arrangements, but it'll be a legal kind of thing, but it'll have nothing to do with marriage.
Where would we stand on parental rights and adoption? I'm trying to figure out how, if we didn't have rights that marriage affords, how we would go about acquiring children through adoption or surrogacy, or how we would go about.
The usual response to that, if I'm going to take a liberty, would be that it would be all contracted.
Privately contracted with an attorney, and yeah, I mean, a marriage license costs what, $35? How much does an attorney cost? I just think that there are, in theory, again, I'm not opposed to that. I'm not opposed to, getting the government completely out of everything, including, anything related to business and family matters and whatnot. But that's not the system we have, and so, I mean, purely libertarianism, that would work well, but today it won't.
We'd have to get our own island. We'd have to get our own island. And I think that's one of the issues, is that there are so many reasons why the state shouldn't have so much control over our relationship, or our jobs, or our pensions, or our Social Security, or our insurance, or our hospital rights. I mean, there's lots and lots of reasons, and I guess I'm too old to find an island, and we really are trying to work and make the system that we have better. And I do think that, interestingly enough, most people really do not want to give up some of the safety nets and the guarantees that marriage offers.
The argument that I hear a lot of religious conservative people say is that allowing people to same-sex couple to get married is infringing on their rights to practice a religion as they want. What would you say to that argument?
What right would that be? Because I don't see what right we're...
I think, well, the argument that I hear is that they have a right as a religious freedom right to say we don't want gay people to get married. So that's...
Well, on December 20th, how many news stories did you see of gay couples lining outside of church doors? 0. Or mosque doors, or any other religious institution that did not want them. What we are fighting for is being married under the law. There are churches and other religious organizations out there that will gladly marry same-sex couples, and if there is a same-sex couple that wishes to get married there, then they can. But this does not infringe on any religion to perform a marriage that they don't want to. This is purely about legal rights, not religious rights. You know, this is not a matter of faith. This is a matter of human rights.
Questions? All right, then we're actually right on our time mark. That's impressive. So I'm going to go ahead and hand the mic back to Zach here in a second. Of course, I can see him across the room trying to do something frantically. But let's go ahead and thank the panelists for joining us this evening. All right. Now Zach's ready. So here you go, Zach.
One more round of applause for these guys. That was amazing. Thank you so much. And as a small token of appreciation, we got you guys a gift, including Porsche dog. Awesome. So that concludes this event. But directly after this, we do have a Liberty on the Rocks event happening at the Beehive Grill. So right after I'm done speaking, if you guys could just exit out this way, or I guess this half connects out this way, this half connects it out into those doors, and then you're going to go into the bar area. So right when you walk in, you'll see these set of swinging doors, and you just walk right in. We're in the back area, and you can go ahead and take a seat there. And yeah, and that's about it. And Liberty on the Rocks, by the way, is a national organization where it just encourages people to get together and talk about liberty-based ideas. And yep, that's about it. So thank you guys so much.